What's happening on those calls you're doing with the enterprise? And then can you maybe give people an idea of what distillation is and why it's so important here?
Let's start with the second thing. Distillation is when you fire up a model and you ask it a question and you observe it and you take its output and you use that in training of your own model. Now multiply that behavior by tens of millions. And what you exfiltrate is essentially trillions of questions and answers. If you really care about distillation, you implement KYC. You force people to make an account, not just with a username and a password, but with some form of identification, maybe with a bounded credit card. There's all kinds of steps that you can take that would frankly slow things down in terms of revenue traction, but would solve the distillation problem on its face. So that isn't really a thing. It's a bit of a red herring.
Distillation is a process whereby you look at the end product that someone else has produced in thinking about and learning about how to engineer your product. It is a common technique that is used across every product category in every industry. At Google, in the early days, we would submit millions of search queries to Yahoo and Microsoft search engines to see what the result sets were. And we would compare our results against their results as a way of improving our search engine rankings and our algorithm. It was a very common technique. It doesn't mean we were stealing their algorithm. We didn't go into their servers and steal their software. We looked at the output of their software and used that to improve our software. Sachs is right. There's a terms of service question here, but that's on the service providers to fix. The terms of service blocking people from doing this if they so chose. But the copyright argument, the IP argument is really about, did they steal the software? They didn't steal the software and they just looked at the output. That's not IP infringement. That's not copyright infringement in the classical sense. And so I do think from a distillation IP argument perspective, it's the output, not the process that matters. So the question is, are they taking copies of copyrighted software and using it, or are they looking at the output? And so I think output, not process of engineering, is what you really need to assess here.
And I think it's a big part of why there's a disconnect on this is there's a huge difference between model weights and outputs, right? So the weights are it's the file of numbers, it's the numerical parameters.
That's the software code. That's the code.
The software. That's the code. And if Chinese companies were to steal
that software,
weights, proprietary weights from Anthropic or OpenAI, that would be theft.
That's right.
But that's not what we're talking about here because no one's accused that. What we're talking about here is taking model outputs and then trying to learn from them. And here's the thing that's so hypocritical is that OpenAI and Anthropic have both argued that they are free to train on all the world's output, regardless of whether the creator wants them to or not.
That's right.
That is their current position. That's like Chamath mentioned the New York Times lawsuit. The New York Times is suing OpenAI right now for going onto the New York Times website in violation of the New York Times terms of service, scraping all the information and training on it. And OpenAI's argument is, look, we're not stealing anything. We're taking the output of the New York Times and we are deriving our own model weights.
100%.
And that is exactly what these Chinese models are doing is they are taking the output of American models and then they're deriving their own weights. They're learning from it.
And so the accusation, though, just so we're clear here, is that there's ethical issues around the industrial scale, covert breaking of terms of service. That's what the White House has been talking about as well.
Yeah.
So now, I'm fine with Anthropic and OpenAI enforcing their terms of service. They need to do a better job, stop the distillation from occurring in the first place. If there are things that the government can do to help them, okay. But I'm not sure what those things are. What needs to happen is those companies need to do a better job enforcing their terms of service.
Content providers, as a group, need to get together and fight for their rights in unison. New York Times, Metacritic.
Fight for the right to party?
No, fight for the right to get paid and to survive.
I'll tell you what I think is going to happen.
ChatGPT and say, as a group, either give us these terms or don't index us. They are interfering with their ability to leverage their own content. It is profoundly unfair.
I'm Daria.
Yeah. Let's just be very clear about what this judgment was and was not. So what Anthropic did is they pirated all these books from LibGen and they trained on them. And the reason why they got in trouble is because they basically took stolen books. They didn't even pay for one copy of them. But if they had paid for just one copy of each book, they could not have been nailed for piracy. They would have been potentially under fair use, which I understand JCal is still being litigated in the courts, but that would have been their defense. So the reason why they got nailed with this $1.5 billion judgment is they wouldn't even buy one copy. It is still Anthropic's position, and it's OpenAI's position, that they should be able to train on all of these books under fair use if they buy one copy. And that issue has not been resolved yet. Now, you should be able to see the total hypocrisy of their point of view relative to the previous issue, which is they believe they should be able to train on every creator's output in the world, as long as I guess they bought one copy of it, against the will of those creators, whether those creators like it or not. They believe it is fair use to train their models and derive their own weights based on fair use. However, they say that the one type of content that you should never be able to train on is their output. That is currently their position. It's completely hypocritical.
What's going to be the problem is the application level layer that you talked about, Chamath. As they go into the application layer and they use this, there's a big court case here. Obviously, you know about some of these, but there are now other cases. There are music cases. There's a New York Times case. The one that's kind of interesting is Thomson Reuters versus Ross. This is a final judgment on AI training copyright. There's a company called Westlaw. They're like LexisNexis, and people have been trying to claim that they can train on the outputs of something like Westlaw. And when you're in the same business as me, that has a special place in copyright law because you're infringing on my ability to use my copyright. And your argument, I think, Freiberg holds up that it wouldn't stop somebody from buying the book. But the second you are actually competing with me like directly, that's when these things have problems. But listen, this is brand new territory. These lawsuits are brand new territory, and IP law does not actually have the nuance yet. So we're going to, as a society, have to make a decision here on what is fair. I suggest, just like the self-regulatory group that we talked about last week, all the AI companies should get together, take 10% of your revenue, put it in a pool, and keep paying the people and getting permission from them so you can get updates on the content.
What Anthropic could have done is they could have said, listen, we have these Chinese companies are creating fake accounts and they're using proxies to basically use our product in violation of our terms of service. Now, using those model outputs is not IP theft because it's fair use. However, it's a deceptive business practice for these guys to lie about who they are when they set up accounts at scale. And so they're engaged in a deceptive business practice. And we're going to do everything we can to stop that, but we'd like the government's help in stopping that too. However, we're not saying anything about IP theft.
Yeah.
Wouldn't that be the more nuanced approach?
Of course.
Because I think that they're on the verge of being hoisted on their own petard here.
We are on the cusp of some type of a settlement getting done here. And I think that would be good for America to take a leadership position in that. Because you do want to keep getting that. But all of these content companies, they should be meeting with each other, the music industry, the New York Times, all of them, to stop their content from getting used without their permission and from competing with them.
And again, if they had just positioned it slightly differently, if they said, look, these Chinese companies are creating fake accounts, that's a deceptive business practice. We're not saying this is IP theft, right? But instead, they said IP theft, and now the whole startup community is activated. You saw that, Gary Tan and 200 startups wrote that letter. Why? Because they know that if this IP theft thing sticks, that all derivative works of Chinese models are tainted now too. So that means the whole startup ecosystem is now at risk.
Yeah.
So I just wonder if these guys have just gone, it's just all a bridge too far.
They decided to engage in this, So they may have poked the tiger. I think it's pretty accurate.